Hello, WiCCD members. My name is Maya Shukeri, and I am WiCCD's Education Committee Director. I'm happy to introduce our series, Finding Your Niche. In this series, we will interview female criminal defense lawyers who practice in a specific area within criminal law. The goal of our series is to highlight the work and accomplishments of female criminal defense lawyers, but it is also a way for us to introduce you to specialty areas within criminal law. We hope we can help you find your niche. Enjoy the series. Hi, Jolene. How are you?
I'm good, thanks. How are you, Maya?
I'm fine, thank you. Happy to see you and to have this chat with you today, where I would like our members to get to know you a little bit better. I know many of us, especially in the Ottawa and East region and also in Toronto, know a lot about you from your work and your involvement in work-related activities and associations. But today the focus is going to be on you. We're going to hear directly from you about what you do and your practice and how you're starting to define your practice and your niche. So, Jolene, maybe we can start by you introducing yourself and telling us where you're based, and then we'll get into your niche and how you got to your niche as a practicing criminal defense lawyer.
Okay, great. So I'm Jolene Hansell. I'm currently an associate lawyer at Russamano Hislop, and I'm based in Ottawa. I've been based in Ottawa for most of my actual practice years, but I actually articled in Toronto before I clerked, and then I ended up back in Ottawa. So since coming into practice, I've been based primarily in Ottawa. I practice, though, across most of the East region. And a big portion of my practice is appeal-based, and I'll have appeal clients all across the province and actually into Quebec. I appear at both the Quebec Court of Appeal and the Ontario Court of Appeal.
All right, so let's then talk about, because I know appeal is a big part of what you do as a criminal defense lawyer. So tell us about how you got into appeals, and if you can just tell us how you were able to, because this is now starting to become your niche. You're really getting into doing a lot of appeals. You're doing this everywhere across the province. So how were you able to develop that niche?
So I think it started with my clerkships, and maybe even actually as far back as my articles. When I was articling with Addario Law Group in Toronto, I had kind of the unique opportunity that year to work on the trilogy of interventions or cases that came before the Supreme Court, Barton, Goldfinch, and RV.
Mm-hmm.
And we were intervention counsel on two of them and actually counsel for the appellant on the third. And that really required kind of this very deep legislative Hansard kind of research in order to understand the legislative provision. And so it started there. And then my clerkships at the Ontario Court of Appeal and the Supreme Court of Canada, I just really liked getting into an argument, understanding the different dynamics of an argument. And what I find most interesting is there's often more than one way to put the argument together, like the pieces of the puzzle. And it's about trying to find the best way to fit all of those pieces together in terms of law and policy that can come into play when we're kind of crafting ultimately what the law should be. So I liked those, and I liked pushing the boundaries of the law and kind of trying to step it forward a little bit. And so I got exposed to those at the Ontario Court of Appeal and the Supreme Court. And then after I finished at the Supreme Court, I started my practice at ALG, which is a firm here in Ottawa. And I had the privilege of working under Howard Krongold, who is a renowned appeal lawyer.
Yes.
And I got to work really closely with him on a lot of files, and I learned a lot from that experience. And just from there, I think it's kind of just continued to grow.
All right. And this is something now that you're doing while you're working with Leo Russamano. And Leo, for everyone who knows Leo, he's also a very known criminal defense lawyer, very known in Ottawa, very well respected.
but he's really known for being a very good trial lawyer. Leo's always doing trials, doing a lot of jury trials as well. So his practice is a little bit different. Like I think he may do appeals, but not as much. So tell us a bit about this dynamic of you being his associate, but you seem to be more focused and interested in appeals more than trials, although you do trials as well. So tell us how that's working out with you and Leo.
So I think it creates like a great balance in terms of a relationship. And I was in court with Justice Weber on a trial case, and counsel got up and said, I'm going to go through my arguments this way. And then he turned and looked at me and said, and I'm looking at the appeal lawyer, wondering if there's a right way to do the WD analysis. And Justice Weber looked at me and said, is there a right way? And I said, well, no, but Justice Watt would say that if you do it this way, you're more likely to get it wrong. And if you do it in this order, you're more likely to get it right.
Yeah.
And so there's this kind of like different value to having an appeal lawyer and appeal perspective when you're doing a trial practice in terms of perfecting the record. And what I also think, so doing the trial things has tremendous value to me on appeal, because the law is only as good as the practical application of it. And if you don't understand how it's going to work on the ground, you're going to create a whole bunch of problems in terms of what you're advocating for. But I think also in terms of, I've learned a lot in terms of the trial pieces of it. And some of the positions that I take on appeal are informed by, all of the years of experience that Leo has on the trial files and how they shape out and work like that. So I'm really privileged as an associate with Leo to be able to develop my practice in the way that's unique to me, and to take on other things in a slightly different direction than is what his typical practice. And I think that it's worked out really well together so far.
Nice. And Jolene, one of the challenges in doing both, because you still do trials as well as appeals, it's balancing the workload because, I mean, as we know, appellate work requires a lot of readings. You're reading a lot of transcripts. Sometimes it's voluminous transcripts. So how are you able to balance a practice where you're doing both appeals and trials at the same time?
It is incredibly difficult. And I think anybody who says otherwise is, being a little bit too kind in terms of the assessment of time. Appeals, I say a good appeal is often 100 hours of work in terms of the time that's spent reading and writing. And what you don't see about an appeal is that it has this one day in court, and often it's an hour's worth of submissions. And the time that goes into that is incredibly important for the outcome, but we don't consider those like trial days in the same way as we would when you're in trial cross-examining ex-witness or whatever's on the stand, and you might have 2 weeks of trial. And so I've tried to block my time in regards to like considering I am working on this appeal, and I consider it like a trial day for my appeal. Like I am not available for this time. It's my dedicated time for my appeal. And I do that with mixed success, because the nature of a trial practice is that things happen and come quickly, and you have to respond to them. One thing that someone told me once, which I took to heart and does work well, is once you open your email, you're done for in the day. So your best writing and research and reading kind of happens early in the morning, and then you can take the afternoon to deal with any fires that have come up that day. So I try to practice that, and at least try to like start my day with 2 or 3 hours of something to get into it, and then recalibrate for whatever else is coming up. And then I think some of it, or a lot of it, is we have a high degree of urgency in this profession, and things come up quickly and last minute. And I think it's really important to like try to keep your eye on what is actually urgent, right? And what needs to get done right now. And for me, somebody in custody who should be released, like, that is incredibly urgent. The world stops turning to address that issue, right? the email that seems urgent is probably something I can respond to tomorrow in a lot of cases. And so it's trying to find the comfort level with those things as to what can wait to tomorrow and what absolutely needs to be done now because someone's liberty is at stake. I think helps in terms of the balance, but at the end of the day, it's imperfect. And like most appeal lawyers, I write a lot of my appeals over the weekends and in the middle of the night still. But I think that's just part of the core a little bit.
Yeah, I mean, like the reality is that we tend to get also very busy, and criminal lawyers, we always like to take on a lot of work. So we end up taking more than what we can handle. And so that's why we end up working until the very last minute because we're always taking on these new cases. And it's hard to say no to people who really need help. So
and it's really easy to push that appeal factum off because it seems like you have so much more time to do. And so I think for anyone who's interested in getting into appeals, it's important to set those intern deadlines for yourself and to hold yourself to them. And I've worked on some appeals with some other colleagues, and those interim deadlines were very helpful and very useful for us, right? Like it must come by this day so that I can read it or somebody else can happen. And it helps keep things rolling.
Now, what's also important in appeals, it's the oral advocacy. Sometimes in trials, it's especially in a judge alone trial, jury trials are a bit different. They require different types of skill set. But if we're just comparing judge alone trial and appeals, like in appeals, there is also this oral submission is also important. So tell us a bit more about that side of the appellate practice, Jolene.
Yeah, so in an appeal, you have like a set amount of time to make your arguments. And if you don't make them, it's kind of like too bad you're out of luck. Whereas you're doing closing submissions in a trial, they're going to give you more time. If you said it was going to be 30 minutes or an hour and it ends up taking 2 hours, they'll give you the time for the most part to complete your submissions. And so part of the art and one of the things I really enjoy about an appeal is you have to figure out not only how those pieces fit together, but how they fit together in a really digestible way for your panel. And leading them through the argument. And there's a really kind of delicate balance on appeal because obviously we're talking to some of the most renowned, legal experts on a particular topic. And of course, they know the WD test or what a Gardner hearing is and things like that. But you do still have to walk them through some of the pieces of those puzzles in order to set up your argument. And so there's a delicate balance that's struck there. Every case ultimately is different and allows you to kind of construct the facts and a narrative in a way that can get you to the legal outcome that you're looking for. And it's often not something that you can see just on reading the judgment. Like very few, I think, appeals you can see, obviously, there's a legal error and this is what it is. You have to really get into the case and read every line of the transcript, even that stuff that happens off the cuff, because sometimes like that's where the gold is. And then just understand why the law is the way it is and what we're hoping to achieve with the rules of evidence or the law being a certain way. And somewhere in that, your argument fits as to why, in this case, your client was disadvantaged by the law or impacted by the law in a negative way, such that they should have a new trial. So there's always some piece of it. And, appeals are interesting because the facts underlying the conviction are not necessarily relevant to the unique legal point, but they're still there, right? The client is still convicted of sexual assault, even though what you're arguing about is whether expert evidence should have been admitted. And there's maybe like a very clear argument about that. And so you have to kind of work the facts to show how that legal error had the impact on your trial such that that verdict is unsafe and it needs to go back or an acquittal needs to be entered because of evidence or something like that.
Now, one of the challenges in appellate work is that you lose a lot of appeals. It's very difficult actually to win an appeal. So this is something that, I mean, many appellate lawyers complain about, that you have to get used to losing a lot before you start winning. And even when you do win, I mean, you're not going to win like every appeal that you're going to be in. But this is actually one of the most difficult parts of the practice, like that a lot of people don't realize how hard it is when we lose, even when we lose a trial. I mean, it's crushing to lose a trial. But how do you deal with that aspect psychologically? Because it is very difficult, it's painful, and it's nobody likes it.
Well, I think you like learn to measure wins in a different way than appeal
Yeah.
allowed. Because if
Yeah.
you measured them that way, then you're right. Something like, less than a third of all appeals are successful, right? So you would end up on the losing side a lot. And so I find when the bench is willing to play ball with my topic and we're having a good back and forth discussion, that's a win in some right? I didn't just stand up there. The kind of the worst thing that can happen on an appeal is you stand up there and speak for an
Yeah.
hour and ask the question because they are never going to go for you in those scenarios. When they call on the Crown, that's often a win because it wasn't so clear cut that they could just dismiss the appeal based on your argument. They have to consider the Crown's. And then reserves and how long something's under reserve
Yeah.
is, something that's winnable as well. But I think like when you're looking at moving the measuring stick forward just a little bit in terms of an area of the law, it's how do I get it to change just a little bit in this case, even if my appeal is dismissed? And how do I move it forward just a little bit or get a little bit more clarity on this point? And you can think of appeal cases almost like these building blocks ultimately in the law, right? Like each case moves the law forward a little bit more. And within the movement, you can get appeals that are allowed, right, as the law is changing. And so I think as you think about it that way, right, I want clarity on this particular point. And when you give me clarity on that particular point, it should mean that my appeal is allowed. And that won't always be the case. But at least if I get clarity on this point, then maybe the next person won't have that kind of problem.
But that's also what I find has been a challenge, and it's how difficult it is to actually change the law. Especially, I mean, we're not talking here about legislation that happens independently or it can happen afterwards, but it is actually a very difficult task, right? And this is what we try to do as lawyers, whether it's in courts, in trials, or in appeals, especially. We're trying to change the law, but it is extremely difficult to do that. And it just seems like sometimes judges are reluctant. There are some areas of the law where it seems no matter what the arguments that we try to advance as defense lawyers, they're not going to be successful. So, what has been your experience with
Well,
that?
it's interesting because, I intervened today for the Criminal Lawyers Association on IM and SB, which were two cases that dealt with the test for when a youth should be sentenced as an adult. And part of the argument the Criminal Lawyers Association was put forward is that the test deals with whether or not like how rehabilitation and reintegration are inherently part of the test when you do it when you interpret it based on the principles of statutory interpretation, and that jail should be only reserved for the rarest and clearest of cases because of the disproportionate impact it has on young people. And I, of course, would like to see the Supreme Court, fully adopt that hook, line, and sinker. But the arguments and the scholarship that we used in that appeal, I actually, after having done the research, started to use it in my detention reviews. When I had an 18-year-old kid who has no criminal record, who's been in custody for 100 days, and as one of those, and it's a tertiary ground detention, in all of the circumstances, you need to consider that this is worse for this 18-year-old kid than it is for something else or somebody who's older. It's separating them from society during their formative period. Like we've seen, and I've had a couple cases that bail can be the silver bullet, right? You get that kid out on bail, they have a house arrest condition, they start going to school, they get a job. 2 years go by before their trial comes around. Even if they're convicted, they've now proven that they are safe in the community. You're way more likely to get a conditional sentence order if you can get them bail by showing those things.
Right.
So it's interesting, the arguments that I try or that we use on appeal actually, I think, impact my trial practice and change kind of the way I approach some of those issues at trial, and can be, more successful in terms of gaining ground, at least in the short term. And then you start to get kind of 3 or 4 decisions that cluster around those things, and you get the transcripts and you file them the next time, and you try to create this kind of cascade of results.
No, but it's interesting here. You did make an interesting point because you mentioned something, an argument that you were making on the Supreme Court, and that you said that, like you kind of had an impact on how that you've been using this for detention reviews. And that's actually a pretty interesting point because I mean, the jeopardy is different here. I mean, when we're talking about the bail stage, the person is still not convicted, the person is still presumed innocent, and the rules are more flexible at the bail level. So there's a lot more to play with as a defense lawyer here. The law can be more on your side just because, it's a completely different situation. The rules are looser. They're not loose, but they're looser, and your guy still, or your client is still presumed innocent. So there's more flexibility. So it isn't an interesting point here to raise that you can actually use those arguments at the bail stage because you have more flexibility, and judges maybe, or JPs may be more open to those arguments, as opposed to when the person is already convicted and the evidence is already out there and they've heard. It's more difficult at that point to make those arguments. So that also is an interesting point when you do both, when you do appeals and you do trials and bail reviews and everything else, that you can use one part to help you in another part or aspect of the criminal proceeding.
You see a different angle on it than I would have thought about before I had written this intervention factum. Right? Yes. It's like, what if I used these pieces and tried to kind of frame my argument on a detention review in a way that shows, the reasonable person would understand why this person with guns and drugs in a very strong Crown case should still be released because they're 18 and they've been in jail for 100+ days and those conditions are really bad. And they could potentially get a conditional sentence order. And I think that the average person would be appalled of the fact that they were in custody for any period of time when they could have been out in the community, and they may be sentenced to a sentence that is served in the community.
And the other thing also is that no matter how strong the Crown case is, you never know when it goes to trial. It could, just they can lose these cases. So it doesn't necessarily mean that it's a slam dunk for the Crown. So that's also something that we need to always remember, that it's not because it's a strong case that's it, the person needs to be in custody. So
well, and I joked to Leo recently that I've developed a niche practice area and finding just enough of a weakness in the Crown's case to kind of crack open the tertiary grounds, right? And whether or not it fully pans out like that at trial, it's just enough to give me a foothold to take that seemingly super apparent case down. Well, there's a bit of a charter here, and here's the newest Court of Appeal case, and this is why. So it does help in that way too.
Yeah. Yes. And that tertiary ground on bail is a very tough one. As if the secondary wasn't tough enough. So then we have the tertiary.
Exactly.
So, Jolene, going back to what you do, so you do appeals, you do trials, and you told us how you find a way to balance kind of. Let's just get real here. I mean, the word balance doesn't really exist. I know we try to achieve and to find balance. It doesn't really exist. There is no balance when you're a criminal lawyer, especially when you're a criminal defense lawyer. But I think that you have to find a way to make your practice livable, that you're able to still have a life while you're doing a lot of work. But you're never going to, I think, achieve true balance because, I mean, you're also a mom, right? So you have to also add that into the equation. So tell us a bit more about that for our WiCCD members, who many of them are moms and who are struggling with that. So if you don't mind sharing a little bit how you're balancing that with your life as a mom.
So I have 2 daughters. They're 5 and 2. And I mean, it's hard. The balance is hard and it's a daily struggle. It's 9 o'clock at night and I haven't been home yet today. So I missed
Mm-hmm.
bedtime tonight. And it works because I have an incredibly supportive partner who's able to help pick up the slack in some of those places.
Mm.
It works because I'm a better mom when I take the time to do the things that are important to me and that are intellectually fulfilling for me. And someone explained or gave me this analogy, and I always thought it was particularly astute. And it's that almost exactly what you were saying. There's no balance, but what there is like two different gas pedals. And when you're in the middle of a 6-week jury trial, like your pedal is all the way down on your criminal law pedal.
Right.
There is no way to do that job less than 120%, right? And somebody's life is on the line. But remembering that when that's over, to take your foot off the gas and then push your family pedal down and to take the space to have those. And so I try to think of them as blocks of time and chunks of time, and then adjust within those to make sure that, I'm feeling like I'm getting all the pieces that I need to have my cup full, right? My cup full with my time with my kids, my cup full with my time with my
But how do
partner.
you explain that to your kids when you have to be away and you have to give your 100% for a long or lengthy jury trial?
It's tricky. And I mean, they don't always understand. Like my oldest gets the concept of jail and she gets what mom does. And she gets that mom's trying to help someone get home to their family. And she would really like, to be home with her family and mom to be home too. And so she gets those pieces of it. And I try to explain it to her just like the best that I can, right? Like this person's having a very big problem and mama can help this person with their problem. And I want to be able to do that.
Mhm.
And so we talk about that, and it's difficult for them to understand for sure, though. But I think they see the different pieces of it that are interesting. I came home the other night and I was talking to my husband and I said, "Oh, I was in court and I argued this." And the 5-year-old's eyes just lit up. "You argued?" "Well, that's what I do in court. I argue." And she was like, "I want to do that." And I was like, "Oh no, I've just created a little monster who's going to argue all the time." But they see the like pride I have for my work and the thing that I do that's important for me. And I think modeling that for them is important. And then we carve out the special time that we have together. So this past weekend, I spent, I don't think I touched my email kind of once over 3 days, and we did lots of different things and they got to pick what they wanted to do. And it was special mama time. And so you find it and you find your way within it, and it changes. And sometimes I need to just like absolutely focus on my kids, and that's what I really need right now. And uh, it all eventually comes together, even like kind of in the middle of it. You can't see how it all works. It does. And it's just like one day at a time, one need at a time, one fire at a time that you're trying to put out, and it all kind of balances out.
Nice. So it's nice that you're able to manage and to communicate that to your kids, because I think it's a very difficult concept for them to understand, like our job and why it requires so much work and so much time away from home. But it's nice. It seems like you do have a very nice system with your daughters, and you never know. I mean, they might end up working with you and arguing with you. It seems one of them at least enjoys arguing. So maybe we have a future lawyer in the making. So
We also have this book someone gave us called My Mommy is a Lawyer, and it explains it really simply, and it covers all kinds of areas of law, but it created this idea that was intangible, right? Like my husband's a teacher, and so that they get, right? Like my 5-year-old goes to school and there's a teacher and she gets that concept. But, this book talks about lawyers protecting ideas and lawyers helping to make sure people are following the rules or building houses that comply with the rules and things like that. And so those are things that she can get and understands that a lawyer does. And she understands it helps a little bit. But I think the thing she takes away from it a lot is that lawyers read and read and read, and she definitely gets that piece of it.
And they spend a lot of time away from home.
Yeah.
So, but it's nice. And I wanted to ask you, Jolene, like seeing how demanding and challenging this work is this something that you would recommend your daughters to do?
I think you have to, like it has to feed your soul in order to keep going and doing it. And because otherwise, I think the burnout or the risk of burnout is just way too high. And so, I mean, I try to be very careful not to kind of like encourage my daughters one way or the other in terms of what they might be interested in. And it kind of changes any given day, you know, what they'd like to be. But if they wanted to pursue a career in law, I would support them if that was something that they were passionate about doing. But I wouldn't, you know, necessarily encourage them towards law just because mom was a lawyer too.
Right. But I mean, even though you know how demanding it is, it's not something that would prevent you if one of your daughters told you that they want to become a criminal defense lawyer in particular, or a criminal lawyer just in general. So you won't be like, no, I don't want you to do this. I know how tough it is, and I don't want this for you. Like, it's not something that you would um, necessarily prevent them from getting into if that's
No,
what they want to
because
do.
no, because I think there's so much that you get out of it. I mean, there's a reason that I'm still in it. There are other
Mhm.
areas of law that I love. I love public international law. I loved contract law too, and like commercial arbitration and things that like don't mix with criminal law generally. But there's something about, you know, you've got these complex legal questions, but then you also have real people and real lives that you're impacting, that makes it meaningful in a more concrete way for me. And that gets me up every day to want to do this. And yeah, it's a lot of work. Yeah, it's really hard. Yeah, I hit the wall sometimes too, like literally and figuratively when we get frustrated about things. But no, I wouldn't discourage them from doing it if they felt like that was what they wanted to do. And I do think, you know, there are pieces of it that we do to ourselves. You talked about, you know, taking on cases, and it's hard to manage like a flow of practice, and you
Yeah,
have cases in the
very
mill and
hard.
things you think are going to trial them resolve. And so you need more cases in order to keep the lights on and trying to find that flow, right? And I think that there's always room for improvement on all of those things and to try to manage it a little bit better. So yeah, I mean, I think that I would, you know, if my daughters wanted to go into criminal law or criminal defense, I would hopefully give them the lessons that I learned the hard way in terms of
Yeah,
organizing,
that's a big
front
advantage
loading some
though.
of my
Yeah.
work, right?
Yeah. And you can help them, right? I mean, especially
Yeah.
if they get into criminal law, they will have a lot of help and guidance from you. Now, just one last thing that I wanted to touch upon, as if you weren't doing already enough and a lot of work. So you're a criminal defense lawyer, full-time, doing trials, appeals. You're a mom, also a full-time job, but you're also teaching at University of Ottawa. So, so you're adding more to your workload. So tell us a bit more about that, and how is that in any way helping you in your work as a criminal defense lawyer?
Yeah, so I think a lot of people see it as adding more work on to the end of my day. The reality is that teaching for me is often a breath of fresh air, particularly in a day that's been spent kind of like banging my head against the brick wall of emails or of like a really unreasonable position that's just going nowhere and everything's getting set down for trial. You get in a room with these, you know, bright and shiny 1L and 2L students who are still like really excited about the law and who aren't jaded and just want to talk
Yeah.
about legal issues and how it plays out. And so I find that to be energizing. Like it gives me energy to keep going on with it. So I teach right now, like this year, I'm teaching a small group in criminal law. And then I'm also will be teaching in the next semester public international law, which is actually the area of my master's degree. and I coach the University of Ottawa's Jessup team, which is the public international law moot team that we do. And I particularly like doing those pieces, the international law pieces, because again, they were something that I was very passionate about before I came to law school. And there's just like, if you want to practice public international law, you have to move to Europe, like the practice area is kind of in the EU for that. But and so it keeps me energized and interested in those areas. And I, do academic research and writing when I have time in those areas of law as well. So I find it stretches my brain in a different way that then gives me energy to go back to some of the other things, maybe the more mundane practices of our criminal law, like our billing, or setting CPTs and things like that. It kind of like helps me keep my own equilibrium in terms of balance. And then for the criminal law classes, they're just such a great sounding board for ideas, and they've got, kind of no limits on the things that they'll suggest, because they just are not bound by the existing framework because they don't know what it is yet. And I find that really interesting in terms of like figuring out what new ideas are for appeals, or how you could craft something, what way the law could develop in a certain way, because ultimately the law is going to kind of settle at the pulse of society. And they are this completely almost non-biased source, right, for you to kind of measure it against.
Yeah. Well, Jolene, it was really so much fun chatting with you today. And although, like we practice in Ottawa, we never really have that much time to see each other and to chat. We're always all very busy doing our own thing, working on our files. So for me, it was very nice to get to know you a bit more and to chat with you. And I'm sure a lot of our viewers are going to really enjoy this interview. It's really incredible what you do. You're doing a lot, and I'm very happy that we had this interview so other people can see and get to know more about who Jolene Hansell is. So thank you so much for taking the time. I know you said you haven't seen your daughters yet today, so I'm sorry. I feel bad that I took some of your time, but I really appreciate it. And thank you so much for being my guest today.
Oh, thank you so much, Maya, for having me. This was great. I'm glad we finally got the chance to do it. And I really enjoyed sharing.
Me too. So hopefully we can have another one sometime soon.
Sounds great.
Take care.